Hello, beautiful people, and welcome to the Service Dog Channel. Do you remember hearing about the 2017 Supreme Court ruling that a little girl could bring her service dog to school? I think that's the only thing I remembered about the case before digging into it. Once you realize what the ruling really was about, you'll realize that the ruling goes beyond just service dogs at school. Let me refresh your memory a little. There was a 5-year-old little girl named Elena Fry who had severe cerebral palsy. Through fundraisers, her community raised $13,000 to help her get a service dog. His name was Wonder, and he was a huge help to Elena, allowing her to become more independent rather than relying on other people to do things for her. Elena got the service dog in the summertime, and when it was time for school to start, they didn't want to let Wonder in the classroom, insisting that an aide could do everything for Elena that a dog would do. The school refused to include Elena's service dog on her special education IEP. An IEP is an individualized education plan, which is the legal document developed under the authority of the Individuals with Disabilities Education Act, IDEA. The IDEA applies to children with special needs. It wasn't until the ACLU decided to represent the Fry family that the school begrudgingly allowed Wonder in the classroom. The family asserted that refusing to allow Elena's service dog in school was a violation of her civil rights. The service dog was not an educational requirement, but a physical requirement for her disability, regardless of whether or not it would be on her IEP, and the IDEA only applies to educational issues, not physical issues. Even though they eventually allowed Wonder in the classroom, they didn't let Wonder assist Elena with anything. They made Wonder lie in the back of the classroom, and he wasn't allowed to be next to Elena or go anywhere with her, like the cafeteria, library, recess, etc. At school, he was useless to her. The school called it a trial period, and at the end of the trial period, they refused to acknowledge that Wonder was even a service dog, and they also refused to say whether or not they would allow him back in school the following year. Because of that, the Fry family decided to homeschool Elena so Wonder would be allowed to help her all day long. In the meantime, the family filed a complaint with the Office of Civil Rights at the United States Department of Education, and the OCR decided that Elena's civil rights had indeed been violated. As a result, the school decided to settle with the family and let Wonder return to school, but they were obviously not happy about it. Because of the attitude of school personnel, the family understandably did not feel comfortable sending Wonder and Elena back to that school. Instead, they enrolled Elena in a different elementary school that welcomed both Elena and Wonder with open arms. Because of the previous school's discrimination, mental harm, and belittling the family, the social and emotional harm caused by the school, the Frys decided to sue the school for monetary damages because of the civil rights violation under the Americans with Disabilities Act, ADA. Can you believe that because of the school's treatment of Wonder, Elena was forced to use the toilet with the stall door open and adults watching her? The Supreme Court heard the case. The problem was that the previous lower court rulings were all over the place, contradicting each other on whether or not a student with disabilities had the right to sue the school for violation of the ADA. Or were they first required to go through the administrative process under the IDEA? You see, there is a difference between disabled students versus able-bodied students being able to sue a school in federal court. A disabled student fell under the jurisdiction of the IDEA. The IDEA guaranteed federal funds to states in exchange for their commitment to provide, quote, free appropriate public education, end quote. Able-bodied students were not subjugated to the resolution process under this act, but could go straight to federal court. Now, since the IDEA had no provisions for monetary awards for damages, suing under the IDEA would not offer the resolution the Fry family was seeking. They wanted the right to sue under the ADA without going through a long, drawn-out process, which would have been a waste of their time and money. The only purpose for doing so would have been to exhaust the IDEA process in order to earn the right to sue the school under the ADA. The Fry family were not alleging a denial of a free and appropriate public education for Elena, which is the mission of the IDEA, but a denial of her civil rights under the ADA. The Supreme Court voted 8-0 in favor of Elena Fry. Supreme Court Justice Alito wrote the final opinion for the court indicating that if the parents sought relief under the IDEA, but found out that the relief they sought, monetary damages, were not available under the IDEA, they would be right to pursue the relief under the ADA, which offers the relief they were looking for, monetary damages. The school did, in fact, violate Elena's civil rights under the ADA. The Supreme Court decided that if the heart of the complaint focused on the IEP, then a family would have to go through the administrative proceedings unless it would be futile to do so. This means that disabled students have the same rights as able-bodied students when their civil rights are violated. All of this is my understanding from what I've read and researched on this case and should not be taken as legal advice. I'm not a lawyer. Like, share, and subscribe.